Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for Steno and Steno related contents. Be ready for the dictation. Ready? Start. Shri Govind Saran, learned counsel for the petitioners, has submitted that the employee was not in service from 1986 to 1997. Stop. He filed the application after 11 years. Therefore, the question of his absorption oblique regularization could not arise. Stop. It was not the case even of the applicant that he succeeded in the test conducted by the department, nor allegations of malafide had been alleged against any person, nor there was any pleading suggesting any illegality or irregularity in the screening test. Therefore, there was no occasion for the tribunal to draw the adverse inference against the department for not producing the policy. Stop. The tribunal could not issue a direction to absorb and regularize the service of the said applicant, as at the most the tribunal could direct to consider his case for regularization. Hence, the petition deserves to be allowed, setting aside the impugned judgment and orders. Stop stanza. Shri Sanjay Kumar, learned counsel appearing for the respondent employee, has submitted that it was an obligation on the part of the department to produce the entire record of selection before the tribunal, and as the department failed to do so, the tribunal has rightly drawn the adverse inference, and thus no interference is called for. Stop. The petition is liable to be dismissed. Stop stanza. The question as to whether the services of certain employees appointed on ad hoc basis should be regularized relates to the condition of service. Stop. The power to prescribe the conditions of service can be exercised either by making rules under the proviso to Article 309 of the Constitution of India or any analogous provision, and in the absence of such rules under the instructions issued in exercise of its executive power. Stop. The court comes into the picture only to ensure observance of fundamental rights and statutory provisions, rules, and other instructions, if any, governing the conditions of service. Stop. The main concern of the court in such matters is to ensure the rule of law and to see that the executive acts fairly and gives a fair deal to its employees, consistent with the requirements of Articles 14 and 16. Stop. It also means that the state should not exploit its employees, nor should it seek to take advantage of the helplessness and misery of either the unemployed persons or the employees, as the case may be. Stop. As is often said, the state must be a model employer. Stop. It is for this reason it is held that equal pay must be given for equal work, which is indeed one of the directive principles of the Constitution. Stop. It is for this very reason it is held that a person should not be kept in a temporary or ad hoc status for long. Stop. A perusal of the authorities would show that appointments are, as a rule, to be made in accordance with statutory rules giving equal opportunity to the all aspirants to apply for the posts, and following the prevalent policy of reservation in favor of scheduled castes, scheduled tribes, and other backward classes. Stop stanza. Whenever the employees are appointed on ad hoc basis to meet an emergent situation, every effort should be made to replace them by the employees appointed on regular basis in accordance with the relevant rules as expeditiously as possible. Stop. Where the appointment on ad hoc basis has continued for long and the state has made rules for regularization, case for regularization of employee has to be considered in accordance with the said rules. Stop. Where, however, no rules are operative, it is open to the employees to show that they have been dealt with arbitrarily and their weak position has been exploited by keeping them on ad hoc for long spell of time. Stop. However, it is a question of fact whether in the given situation they were treated arbitrarily. Stop stanza. The other contention taken by Mr. Francis that criminal proceedings which were initiated against the respondent ended in acquittal on merits and that became final. Stop. A lenient view must be taken since the charges in both the cases are identical. Stop. We have already elaborately discussed about this point factually and also with reference to the judgments referred to supra, and for the reasons recorded earlier, we reject this contention. Stop. The order of dismissal passed by the disciplinary authority was based on dispassionate and independent examination and appreciation of the entirety of facts and evidence on record relating to the malpractices and misappropriation indulged in by the respondent in collusion with the other members of the staff, causing thereby huge loss to the corporation. Stop stanza. The scope of disciplinary proceedings and the scope of criminal proceedings in a court of criminal law are quite distinct, exclusive, and independent of each other. Stop. The prosecution proceedings launched against the respondent herein were in respect of offences punishable under sections 409 and 477 IPC, whereas the departmental proceedings as initiated against her were in respect of the charges of misappropriation and other fraudulent practices such as deliberate omission to bring into accounts the stock received showing bogus issues in the records, falsification of accounts, submission of defective accounts, tampering of records, manipulation of accounts and records, etc. Stop. Thus, the respondent herein was proceeded against for quite different charges and on different sets of facts before the court of chief judicial magistrate on the one hand and before the departmental inquiry on the other. Stop stanza. The orders passed by the disciplinary authority as well as the appellate authority are not only bad on facts but also unambiguously supported by unassailable reasons in support of their conclusions. Stop. Thus, the unchargeable ex- acquisition by the learned single judge and of the learned judges of the appellate bench that the order of the disciplinary authority and of the appellate authority suffer from total non-application of mind is patently devoid of any substance of truth and law. Stop. It was submitted that though departmental actions initiated against the 11 employees and some of them were reinstated who were also involved in the same offence and therefore a direction should be issued to the appellant corporation to take the same view insofar as the respondent is concerned. Stop. We directed the learned counsel for the appellant to ascertain the correct position insofar as all the other 11 employees are concerned. Stop. Mr. Ambrish Kumar, learned counsel appearing for the appellants on instructions from the corporation, submitted a memorandum stating that out of 11 employees, 9 were dismissed from service, including the respondent herein, and 2 employees were not charge sheeted. Stop. In the instant case, the charged employee holds a position of trust where honesty and integrity are inbuilt requirements of functioning, and therefore, in our opinion, the matter should be dealt with firmly with firm hands and not identity leniently, and the respondent deals with public money and engaged in financial transactions. Stop stanza. Therefore, highest degree of integrity and trustworthiness is must and unexceptionable. Stop. Judged in that background, the conclusion of the learned single judge, as affirmed by the division bench of the High Court, do not appear to be proper. Stop. We have no hesitation to set aside the same and restore the order passed by the disciplinary authorities upholding the order of dismissal. Stop. The civil appeal stands allowed. Stop. The orders passed by the disciplinary authority and the appellate authority ordering dismissal is confirmed and the judgment passed by the learned single judge in writ petition as confirmed by the appellate judges are set aside. Stop. However, there will be no order as to cause stop.